allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Welcome. We'll begin by reviewing the draft minutes of our previous meeting held in October 21st, 2024. I make a motion to approve the minutes. Would a member second? I'll second. Thank you. All in favor? Aye. Approved without amendments. We'll review the agenda as is posted on the town website. Agenda for the Town of Brunswick regular meeting, November 18th, 2024. We'll begin with AJ Signs at 625 Brunswick Road, the sign variance, followed by Froyo at 502 Pinewoods Avenue, an appeal. Next will be Atlas Renewables, Brunswick and Sickaway Solar, Shippey Lane, Brunswick Road, use variances. And we have one item of new business, Kiefer at 22 Grange Road, seeking an area variance. We'll ask the representative for AJ Signs to come up and just present a brief overview of your project. Oh, so sorry, yes. After we'll read, first read the notice of public hearing. Thank you.
Notice of public hearing. Notice is hereby given that a public hearing will be held by the Zoning Board of Appeals of the Town of Brunswick at 6 p.m. on Monday, November 18, 2024 at the Brunswick Town Hall, 336 Town Office Road, Brunswick, New York, 12180. Concerning the application submitted by AJ Signs for 3 sign variances in connection with a business use on property located at 625 Brunswick Road. The application requests 3 variances. Front setback of the building on which a wall sign is proposed from the front lot line, the amount of road frontage for the parcel, and front setback of the proposed freestanding sign from the front lot line. Copies of the application are available at the Brunswick Town Hall and are available for public inspection during regular business hours. All interested persons will be heard at the public hearing. And the notice was published in the Eastwick Press, placed on the town signboard, posted on the town website, and mailed to owners of properties within 300 feet of the project site. And we will confirm for the record, in the event the application still, or at least the application records indicates there were additional variance requests for number of signs on the building, as well as a sign on the side wall of the building. If the applicant can just confirm for the record that those requests have been withdrawn. Thank you.
So we're just looking for a freestanding sign where one is not allowed. It's very simple, just the letters illuminate at night, throws with mechanics. It's very, very dimly lit, throws no more light than a traffic light. Other than that, the freestanding sign, we kept within the square footage. You know, if other businesses are allowed a freestanding sign, so we didn't make it any larger. I think we did confirm that it doesn't hinder any site when pulling in and out of the lot. Are there any questions?
Not at this time, thank you.
Great, thanks.
The zoning board will open the public hearing portion of this application. If anyone would like to speak for or against the application, you're welcome to come up and do so. Hi, how are you?
Good. My name is Pam Harder. I live at 14 Leonard Avenue, which is the road that leads into. I have no objections to, unfortunately, the signs they withdrew, the ones that were going to go right on the building. I have no objection to. It's that freestanding sign that I do have an objection to. I know they went and took pictures. From the pictures, it looks great, like you still have a good view. However, to really get a good view, you have to pull forward and actually be in the crosswalk, okay, which you're not supposed to do. And I did go back and listen to the meeting minutes, the video from the last time, and they did mention that the reason they wanted the freestanding sign was because of the bushes on the other corner hinder the view of the building. Well, those bushes on the other corner, for years now, have been, they're supposed to be loved. It was something stated a long, long time ago, when my grandmother lived there. So those bushes need to be addressed because they've gotten way out of control. You can't even see the sidewalk anymore. I can't see, pedestrians coming up until they're right on the corner. So if the bushes were addressed, they wouldn't need the freestanding sign. Because then you could see the sign on the side of the building approaching, and you would be able to see the one on the front of the building. So. And the lighting on the sign, she said the light was going to be lit if it's the freestanding sign. That kind of worries me at night. More lights in our faces trying to come out of that road, and we have no other option to that end road. So, those are my concerns. Thank you for listening.
Thank you.
Hello, I'm Ernie Burkhart, I live at 9 Leonard Avenue. I have the same concerns as Pam. The freestanding sign, I believe, would be a bit of a hindrance on trying to find a way out of that road, as well as trying to look to the right with bushes. It is hard that way, but with the freestanding sign there, like she said, you would have to pull up even farther into Brunswick Street or even be parked onto the crosswalk, which I don't think would be safe either for either pedestrian or any other oncoming traffic. As for the signs being on the building, the other ones have been there for years. They haven't ever been any kind of issue. Again, the issue is the freestanding sign that's being proposed.
Thank you. Are there any other public comments? Are there any questions from any of the zoning board members?
I have a question about the lighting. Is there going to be a time off of the lighting that's been proposed?
You can put a timer on that, if you'd like, but we were just gonna put it on photo cell for now, so it's come on, the lights dim. But we could put it on a timer, so we could turn off like 10 or 11 o'clock at night.
Historically, we'd asked establishments along Brunswick Road to be lit during their hours of operation.
Yeah.
Do you happen to know the medical office's hours of operation?
I believe they plan on staying up until 8, but I can confirm that, I'm not quite sure at this specific location.
Has there been any consideration to the signage being suspended like in the air, like, so it's not in view?
We were very careful with the design of the sign for the height and exactly where we placed it, to make sure it didn't, interfere with drivers turning in and out. So the way we designed the sign was pretty much as good as we could for the location. Height-wise,
Yeah, I'm just thinking the folks that came up, indicating that there's an issue with going out of there, being in the crosswalk. If the sign was elevated, you would have that issue. So I don't know if that's maybe something that they would consider.
I'm sure we
The
could make it
property.
taller. I'm sure we could make it bigger, taller, if that's what we would like.
Are you saying so that?
So a pylon sign?
Yeah.
A pylon sign versus a
Correct.
monument sign?
Can you kindly confirm the dimensions of the sign, please?
The sign including the base right now is 98 inches tall, and including the base, it is 96 inches wide. The actual sign portion that says Ebros Orthodontics is 42 inches tall by 92 inches wide.
Thank you.
If I do make that taller, it is gonna increase the square footage though, so I believe I would need another variance. Square footage wise?
So I was trying to if I was understanding you correctly, so the way that you're talking about a sign that's suspended, that means that there is vacancy between the ground and the sign? There's going to be like a clearance way?
Right. Like.
Like
now-
Ted's, like Ted's. Ted's has
Yeah.
a,
And the folks across the street, there's, I think Advances it's up high, like on a pole or something.
I could check with my client, but we could do a pole sign.
And I think it would mitigate the concern, I don't know, we'd have to see what that looks like though. Like how high is it? And
Do you have a height requirement here?
We do. That's the height requirement for signs.
Yeah, I have to look it up. I don't have the book in front of me.
We can do that for you.
you may know where that's at.
Certainly, yes. Public hearing, for it's still open.
What was the purpose of eliminating the building signs and just almost the sign?
Let's see if we can get that answer for you here. Would you like to address that question?
Sure. My client originally wanted 3 signs. He wanted to grab a freestanding sign and also 2 wall signs. But in hopes we got the freestanding sign, which is much more visible to drivers, we agreed to drop the other wall-mounted sign because it was a little bit redundant in my opinion. So we want to minimize the variances and hopefully the freestanding sign improved on that side of the building.
So they can be up to 30 feet.
Okay.
And there's a couple other calculations I got to put into it, but 30 feet.
Another question, is there a requirement on how far away signage has to be from fire hydrants? Because it seems like that fire hydrant is only mere 8 to 10 feet away from where the proposed sign is.
I couldn't tell you. I can tell you need about 6 working feet around it,
6 working
only
feet.
from my experience, but that's not the,
Right.
that's not based on the board's idea, that's my personal.
Yeah, that's not.
And my second concern with the height of the sign, if we were to go with a pedestal sign, for lack of a better term, there's also snowbanks that go there during the winter seasons, which can also hinder our view. They go 6 to 8 feet tall with a decent sized snowstorm, so that might want to be into consideration too when putting in the sign.
So generally, I think what Member Lockrell was stating was to have a pylon type sign, right, that's elevated,
Right.
that I would assume would be somewhere around at a minimum 10 feet high
Can't be high.
at the base. Okay, that should mitigate that issue.
That way there's enough room to see under the
Correct.
sign.
And whether it's held up by 1 or 2 pylons, that you would be talking probably, I would assume, like 4-inch steel, something like that, would be obviously minimally invasive to your concerns there. So would that be more of accommodating to the folks coming out of that area? I mean, we're trying to find a happy medium.
Right,
so-
I understand, I haven't had these concerns as well as you guys do, you guys think of a lot too, but sometimes
Sure.
these other ideas.
Yeah, thank you.
Good evening. Hi, I'm Lisa Burkhart. I live at 9 Leonard Ave. And I just wanted it to be noted that back a few years ago, my mother actually had an accident at the end of our road because she was not able to see the traffic coming down. And she went to pull out and somebody was right there and nailed her right in front of her car. So I would like that noted as well, is that we have had an accident at the end of the road because not being able to see. At the time, the bushes were out in front. Obviously, through the years, the bushes have been removed. we don't need any more obstacles to block our view from being able to get in and out of that road. There's too much activity right now in that vicinity, and a freestanding sign is not one that we need at this time.
Thank you. Any other questions or concerns? So I would ask the applicant if you would like to go forward with the proposal that the zoning board members have in front of them right now, or would you like to communication with your client to discuss what was brought up here, if there are any alternative options to a sign? So we could either go forward with what we have, or you can take the time that you need to communicate what has been discussed and to make another decision on how you want to proceed.
If we revise our application, what would that look like? Really?
Certainly, so it would be in conjunction with the building department. We would work with them to make sure you're meeting the setbacks for a sign variance and the size and the dimensions of the sign.
So if I want to revise this, I can table this today and then we can come back in another meeting.
So Andy, I'll ask you for
It would be.
what is at the time.
I would think this, given that these issues arose during the public comment period in this application, if this was in relation to responding to public comments and amending the application, I think it's properly viewed as an amended application. That does give rise to questions about the public hearing. You may want to choose to keep the public hearing open until potentially those amended plans come in. So the public gets a chance to see them and comment on them as well before you close the public hearing, but that's within the board's discretion.
I think I would like to do that. I can speak with my client and then revise our application based on the comments this evening.
Certainly. And I would make a motion to keep the public hearing open, waiting the revised materials. We can continue this into the next meeting, which is in December. That meeting is December 16th.
Second that.
Thank you, John. All in favor?
Aye.
So the public comment period is open for receipt of more comments that we will hear at our next meeting from the applicant. That they'll make revisions to the application that they presented for this sign. Any questions now? Okay. Okay, thank you very much.
Thank you.
Okay, thank you. Good night. Stay home. Good night. Good night. Okay, our second item of business on the agenda is Froyo at 502 Pine Woods. I'll ask the applicant to come up. And the zoning board will open the public hearing portion of this application. We'll note that it's published in the Eastwood Press, placed on the town signboard, posted on the town website, and mailed to all owners of adjacent property within 300 feet. The attorney will now read the hearing public notice.
Notice of public hearing. Notice is hereby given that a public hearing will be held by the zoning board of appeals of the town of Brunswick at 6:15 p.m. or as soon thereafter as may be heard on Monday, November 18, 2024, at the Brunswick Town Hall, 336 Town Office Road, Brunswick, New York, 12180, concerning the appeal submitted by Zachary Froyo for property located at 502 Pinewoods Avenue. The appellant is appealing an interpretation of the Brunswick zoning law made by the Brunswick Building Department concerning the appellant's special use permit application, specifically that the proposed use is not in compliance with the Brunswick zoning law. Copies of the appeal are available at the Brunswick Town Hall and are available for public inspection during regular business hours. All interested persons will be heard at the public hearing.
Thank you very much. Can you kind of introduce yourself and give a brief overview of the project, please?
Sure, thank you for hearing me. My name is Amy Bellantoni, I'm the attorney for Zachary Froyo. I have submitted Mr. Froyo's appeal of the building department's determination that the amendment of his existing permit would be considered a retail sale and therefore prohibited because it would take place at his residence, which is in residential zoning. Did you have a question? Okay. So just by way of brief background, Mr. Froyo operates a part-time online sales business. His full-time jobs in construction, and that is, the majority of his time. So this is not a full-time business to begin with. All of the sales that are taking place under that FFL, that gun dealership license, he's licensed by the ATF. All of those sales are taking place online, have been taking place online or by the phone for years now under his existing permit. So that being said, the interpretation by the building department that an amendment would classify Mr. Froyo's use as a retail sale is inaccurate because he is already engaging in sales. He already has a permit to do that, and the sales are not taking place in a retail sense, and that no one is coming to his home to purchase anything. There was no showcase, there was no foot traffic. It's all done online and over the phone. The reason for the application to amend his permit was because New York State in 2023 instituted new laws that require FFLs, federal firearm licensees, to conduct background checks when transferring ammunition. So in other words, if a retail sale online or over the phone took place with one of Mr. Froyo's customers, he could no longer ship the ammunition straight to their home. Now, New York State requires that they meet with him and have a criminal background check conducted. The second issue that arose in 2023 is that Mr. Froyo had contacts in other gun dealerships in the area that would conduct the transfers for him at their locations and now are no longer willing to do so. So in that sense, the individuals who've already purchased ammunition or other products from Mr. Froyo's business would be coming to his home solely for the purpose of having a background check conducted and leaving with the product that they had already purchased. So in other words, New York State is requiring more along the lines of what could be deemed a service to these already paid customers rather than a retail sale in that respect. Now, the building department noted that there is no definition of retail sales in the zoning laws, right? So it's an undefined term. And as I've already explained, the retail sales have already occurred by the time the customer would be coming to Mr. Froyo's home. And it should also be said that Mr. Froyo, when he requested or applied for this amendment, sought only permission to have one person, one of those customers, come to his home per week. It's very limited. And at the planning board's suggestion, his application was amended to allow 3 people per week, but no more than 1 per day. A very low amount of, really no discernible change to foot traffic, zoning, pedestrian or more vehicle traffic to his home. In other words, if it were friends and family, which are the majority of the individuals who have been purchasing up to this point ammunition and other products from Mr. Froyo, there would be no discernible difference in who is coming and going from his home. I noted in the appeal that on the website for the town, it indicates that the amendments to the zoning regulations now allow for in a residential area, dog kennels and bed and breakfasts. So presumably, if a dog kennel can be placed in a residential area and not affect zoning, there would be significantly more traffic and or noise and congestion to whatever extent, necessary depending on the wording for that specific type of business. Mr. Forio's amendment would be more along the lines of an accounting firm that handles business and services for their clients, and then, let's say, a customer needs to come in to the home and sign their tax return or pick up their tax return and then leave. It would be pretty much akin to what Mr. Forio is requesting. There was also a concern, withdrawn. The building department also pointed to in its determination the definitions of retail establishment, which I submit are completely inapplicable and not comparable to Mr. Forio's requested amendment. Under the zoning laws, the retail establishments are enumerated and really are more along the lines of convenience stores, gas stations, lumber yards, and large commercial buildings with signage and actual retail shelves and shelving and products for people to come in and out, and would more likely to attract high volume as opposed to by appointment individuals coming to Mr. Forio's home simply to have a background check conducted. Additionally, you should note that on his website for Freedom Arms USA, he doesn't list his address. As I noted, all of these individuals, to the limited extent that they would be allowed to come to his home, would be solely by appointment. And by not having his address published on the website, it would eliminate any idea or speculation that individuals would just be driving to his home, to try and, I guess, look at whatever inventory, which he doesn't keep an inventory. But in other words, you're not going to be inviting people, strangers, to be coming into town, unannounced to his home. So it asks that their determination be rejected and set aside, and that Mr. Forio's application to amend his existing license be granted. Are there any questions?
I have a few, but we'll allow the public to speak first.
Thank you.
Thank you. So hearing that overview, if anyone from the public would like to speak for or against this, sorry. Oh, okay, certainly. So we'll now allow the building department to present its case. Thank you. Mr. Chaffee, welcome.
Yes, good evening.
Good
Thank you.
evening.
I'm Tom Chaffee. I'm here representing the building department, as Mr. Gilchrist said. I'd like to hand out to the board on papers.
Certainly, yeah, thank you.
So here are, here's the original for the chair. The rest of these are copies we need to send. May I give one to council?
Yes, please, thank you. And for the bill.
Lucky day.
Should I go ahead and, do you want my detailed response now? I'm not really sure how you want me to.
Generally reviewing it, and then the board will review it in more detail.
Right, well, I have a. Anyway, just wanted to start out by saying, my name is Tom Chaffee and I'm the Brunswick Town Attorney. And in that capacity, I'm representing the building department in this appeal. I want to stress that I'm not the attorney for the Zoning Board of Appeals, nor do I represent the Zoning Board of Appeals, nor should anything I say or anything I submit to the board in connection with this matter be considered as giving my legal advice or legal representation to the board. Rather, I am legally representing the interests of the town building department. As you all know, the The zoning board of appeals has its own attorney, Mr. Gilchrist. This appeals to a determination issued by the town building department on or about July 16, 2024, in connection with an application for an amended special use permit dated April 5, 2024, filed by Zachary Froyo with respect to his home located at 502 Pinewoods Avenue in the town of Brunswick. Mr. Froyo had previously applied for and received a special use permit for this property issued on December 2, 2021 from the town of Brunswick Planning Board, permitting him to engage in a home occupation as the term is defined in the Brunswick zoning law, involving the sale via internet and telephone only of firearms, ammunition, and related accessories from his home, subject to various stated conditions. Mr. Froyo now claims that various circumstances have changed which necessitate that his special use permit for a home occupation and the conditions thereof be amended in order for his business to continue to operate. I've submitted the board a memorandum setting forth in detail our position. We ask the board to consider the same. I would also like to further address our position at this time. Since Mr. Froyo's home is located in an A40 district, his property is not zoned for commercial activity, which involves the retail sale of goods to ultimate customers, consumers. It appears that a decision was made by Mr. Froyo at some point to realize his goal of selling firearms and ammunition and related accessories from his home by pursuing it as a home occupation under the town zoning law. Our current zoning law was enacted in June 2017, thus provide for home occupations. Although I have quoted the home occupation contained in the current zoning law in my memorandum, it is not a terribly long definition and I'd like to read it now. This is a quote: home occupation, any personal, professional, or trade services customarily conducted entirely within a principal or accessory residential structure, which use is clearly incidental and secondary to the use of the property for dwelling purposes and does not change the residential character, with no retail sales therein, and such use shall not exceed 30% of the total building floor space, excluding accessory and outbuildings. The home occupation is conducted primarily by a member of the family residing in the dwelling unit. In addition to that definition, there are other requirements pertaining to home occupation set forth in section 16039 of the Brunswick zoning law. Under the 2017 Brunswick zoning laws, home occupation is use allowed by special use permit in an R40 district, which is where Mr. Froyo resides. Regulations pertaining to special use permits are set forth in Article 8 of the zoning law. I will later discuss the application of those regulations to the matter now under consideration. It's also important to point out that the town provided for home occupations as part of its zoning regulations even before the 2017 zoning law was enacted. The town enacted a zoning ordinance in the late 1950s, which also provided for home occupations. I've included that definition in my memorandum. I won't read it because it's a bit longer than the current one, and it no longer applies, and it's noteworthy only in what it doesn't do. Specifically, while the home occupation definitions in the now repealed zoning ordinance and the current 2017 zoning law are similar in many respects, one notable difference is that the one contained in the current 2017 zoning law, which I just read, expressly prohibits retail sales as being part of or within a home occupation by including the language with no retail sales therein in the definition. The definition in the now repealed zoning ordinance contained no such prohibition. We believe this to be noteworthy as it indicates that the town board had clear intent at the time it enacted the 2017 zoning law not to allow retail sales activity within or as part of home occupations going forward. Additionally, under the now repealed zoning ordinance of the town of Brunswick, home occupation was considered and treated as an accessory use. It was not subject to special permit review or issuance by the planning board as it is now. With that out of the way, let's turn to what specifically occurred in this case. Even though this appeal involves a building department termination, which occurred in the context of Mr. Freuder's application for an amended special use permit for a home occupation, we think it's important to go back to the beginning and discuss what occurred in connection with Mr. Freuder's original application for a special use permit, which was ultimately granted by the planning board subject to conditions. Mr. Freuder first applied for a special use permit on or about September 10, 2021. I've included a copy of his application with my memorandum. In explaining that his business would consist of sales of firearms, ammunition, and related accessories by internet and telephone only, Mr. Freuder used statements like, and I quote, "No customers would be entering his home," and quote, "There will be no customers coming to my home." In the context of appearances before the planning board and the public hearing, which were part of the special use permit process, Mr. Freuder explained his business model for his home occupation essentially as this. A customer would contact him via internet or phone and ask him to obtain a specific firearm. Mr. Freuder would quote the customer a price, and the customer would pay Mr. Freuder the amount Mr. Freuder charged. The customer would include his markup fee and the applicable sales tax. Mr. Freuder would then order the firearm from the firearm manufacturer or an authorized distributor, and it would be shipped to another federal firearms licensee having a brick and mortar gun store, who would conduct the required background check on Mr. Freuder's customer and then transfer the firearm directly to the customer. After the public hearing on the initial special use permit for Mr. Freuder's home occupation was closed on November 4, 2021, the matter was referred by the planning board to the building department for a determination as to whether the business proposed to be completed in Mr. Freuder's home, as described by Mr. Freuder in his application and other statements, falls within the definition and other criteria for a home occupation as set forth in the zoning law and is otherwise compliant with the zoning law. Such determination is required under section 160-64 of the zoning law. I've quoted that entire section in my memorandum. This determination of zoning compliance or not is an essential part of the special use permit approval process. Under Article 8 of the zoning law, such a determination is required for every situation in which a special use permit is the relief being sought, not just home occupations. Only after a determination of zoning compliance is made by the buildings and code inspector can the planning board move forward and assess what impacts and adverse effects the use proposed on the specific parcel involved will have on adjacent lands, the immediate neighborhood, or the character of the community, whether those impacts can be mitigated, and ultimately whether a special use permit will be granted and on what conditions, if any. If the building and code inspector determines that the proposed use of the property in question is not zoning compliant, in some respects, the process ends, and the special use permit application is denied, subject only to an appeal to this board. Town buildings and code inspector did issue his determination as required by section 160-64 of the zoning law in this matter, dated November 18, 2021, a copy of which is attached to my memorandum as Exhibit 5. The buildings and code inspector acknowledged the language and the definition of home occupation contained in the zoning law that prohibited retail sales and home occupations, specifically the no retail sales therein language. The buildings and code inspector then noted the term retail sales contained in the definition of home occupations was not defined in the definition of home occupation or elsewhere in the zoning law. He went on to discuss a number of commonly used definitions of retail sales that he had found elsewhere, such as, quote, the retail sale occurs when a business sells a product or a service to an individual consumer for his or her own use, unquote. Other sources, he said, define the term as a, quote, sale to an end user, unquote. The determination also reviewed several of the other criteria for a home occupation contained in the zoning law, and ultimately concluded that the home occupation proposed by Mr. Froyo was compliant with the zoning law. Specifically regarding the prohibition against retail sales set forth in the definition of home occupation contained in the zoning law, the buildings and code inspector stated as follows, and I quote, "The description of the home occupation that is being proposed is a very low impact in that there will not be any customers coming to the residence because the sale portion of the business is through the internet and all of the items will be shipped to the end user directly or to a store to complete the transaction. There will be no products for sale from residents and therefore no customers." It is clear that, and that's at the end quote, it is clear that the determination of the buildings and code inspector was premised on the fact that since the firearm or anything else being purchased was not under Mr. Froyo's proposed business model to be delivered to the purchaser of Mr. Froyo's home under any circumstances. In his view, the retail sales transaction was not being fully completed within the Froyo home, and the retail sale therefore did not occur therein, and the prohibition on retail sales in the home occupation definition was not triggered and therefore did not apply. Thereafter, and on December 12, 2021, it having been determined that Mr. Froyo's proposed occupation was zoning compliant, the planning board conducted its special permit review and granted the special permit for Mr. Froyo's home occupation subject to 6 conditions. The first and ultimate condition of the special use permit was that the firearms sold by Mr. Froyo to his customers would not be delivered to his customers in Mr. Froyo's home. Fast forward to sometime in 2023. Mr. Froyo comes to the conclusion that circumstances had changed since a special use permit for home occupation was approved by the planning board, which made it impossible for him to continue to operate his business out of his home unless the terms of the special use permits were amended to allow him to have a limited number of customers come to his home in order to take delivery of firearms and ammunition purchased from him and submit the required background checks. He described these changes of circumstances essentially as follows. New York State law was amended to require that background checks be conducted through the New York State Police for every ammunition purchase, and that all ammunition purchases be transferred in person to the customer. Prior to this change in New York State law, Mr. Froyo had ordered ammunition as requested by his customers online, and after they paid for it, he had it drop shipped directly to his customers. This was no longer legally permitted. The brick and mortar firearms dealers, gun stores that Mr. Froyo had been using to conduct background checks and effect the actual delivery and transfer of purchased firearms to Mr. Froyo's customers had stopped doing so, essentially claiming that Mr. Froyo was a business competitor of theirs and was taking business away from their brick and mortar stores with his home-based business. So Mr. Froyo then files an application for amended special use permit. Like in the application for the initial special use permit, there were some meetings before the planning board as regards the amended special use permit application, including the required public hearing, at which the above issues were discussed and comment from the public was received. And once again, as in the case of the initial application, once the public hearing was closed on May 2, 2024, the planning board asked the town building department for the determination required under section 160-64 of the zoning law as to